the Monday surprise. Most firearm attorneys and analysts expected this week's Supreme Court orders list to be a massacre. 41 gun cases sitting on the Supreme Court's orders list, with lower courts openly defying Bruen and daring the justices to intervene. The prediction across nearly every 2A legal circle was simple. Half of them would get denied, and the other half would get buried in procedural limbo. But that isn't what happened. Today, the court spared nearly all of them. What looks like nothing to the casual viewer is actually a strategy, and gun owners need to understand the strategy because it determines how magazine bans, felon in possession laws, disarmament statutes, and concealed carry reciprocity will play out over the next 12 to 18 months. This wasn't mercy, it was sequencing. Now let's break down what survived, why it matters, and what comes next. If you want ongoing updates as the Supreme Court plays this chess match out, subscribe. It matters more than ever. Section 1. What did not happen today? The biggest story from today is the thing that didn't happen. Many court watchers predicted a bloodbath at the Supreme Court. Dozens of Second Amendment petitions sat in conference, and the expectation was that the court might deny or kill off large blocks of them in one sweep. Instead, almost every major petition survived. Nothing collapsed. Nothing was cut loose. For gun owners, that instantly changes the temperature. When the court does nothing, that isn't neutral. In Supreme Court terms, doing nothing is often a signal. It tells lower courts to hold still. It tells litigators that petitions remain viable. And it tells the broader legal ecosystem that the court isn't done with the Second Amendment yet, even if it hasn't revealed where it's headed. From a gun owner's perspective, the real effect is stability. State governments can't celebrate a denial. Anti-gun litigators can't declare victory. And gun rights lawyers don't have to restart their strategy from zero. Short takeaway. The court kept the board intact. Nothing collapsed. The Second Amendment docket remains alive, and this is not what many expected, and that's the point. Section 2. The 41-case pileup. The Supreme Court doesn't just wake up one morning and find 41 firearms-related petitions sitting on its desk. That kind of concentration only happens when the lower courts are no longer speaking the same constitutional language. And after Bruen, that is exactly what has occurred. The 2nd, 7th, and 9th circuits have tried to reinterpret Bruen around their preferred policies. The 5th and 3rd have taken Bruen at its plain meaning, and the 1st, 4th, and 11th circuits are trying to figure out which side to join. When the court sees that level of divergence, the docket becomes less about individual cases and more about the systemic failure of uniformity. And here's the critical part. A fractured system forces the court to keep cases alive until it has enough information to decide which fractures matter and which fractures can be ignored. That's why today wasn't a denial event. It was a triage event. From a gun owner's perspective, the existence of 41 petitions tells us something important about the era we now live in. The Second Amendment is no longer a niche constitutional amendment. It is now a national legal field with full-scale litigation across circuits. Short takeaway bullets. 41 cases equals circuit breakdown, not coincidence. After Bruen, appellate courts no longer agree on the rules. SCOTUS preserved the field instead of shutting doors. Without a single ruling, the court confirmed that the Second Amendment docket is now too big, too fractured, and too important to resolve with one swing of the axe. Section 3. Gardner versus Maryland refuses to die. If there's a case you wouldn't expect to survive the sorting process, it's a pro-SC petition from a concealed carrier named Gardner. No big national organizations, no high-profile litigators, no donor war chest, and yet Gardner versus Maryland not only survived, but the Supreme Court also forced Maryland to respond. That matters for two reasons. First, the issue is relatable and unavoidable. Can a lawful gun owner defending themselves in one state be prosecuted for crossing into another? That question lives at the intersection of concealed carry, reciprocity, self-defense, and interstate travel, exactly where millions of gun owners operate without clarity. Second, the court doesn't force responses to petitions it considers unserious. For gun cases, that standard becomes even higher. The court's intervention shows that Gardner raises a problem the court has avoided for too long. Is the right to self-defense tied to zip codes, borders, or constitutional citizenship? For decades, hostile states like Maryland, New Jersey, and New York have treated out-of-state concealed carriers as criminals first and victims second. Gardner exposes the absurdity and the human stakes far better than a rifle case or a magazine case ever could. Short takeaway bullets. Gardner frames the Second Amendment as self-defense, not politics. Reciprocity problems become constitutional problems. The court forcing Maryland to answer means the petition matters. What makes Gardner dangerous in the best way is that it forces the court to deal with the practical world gun owners actually live in, not the academic one lower courts prefer to debate. Section 4. The 922 G1 Cluster and Felon Question. The largest block of petitions the Supreme Court reviewed wasn't about magazines, rifles, or permits. It was about who counts as the people under the Second Amendment, specifically the 922 G1 Felon in Possession statute. 39 separate petitions piled into the conference, all orbiting the same fundamental issue. Does a conviction permanently erase a constitutional right? And if so, based on what principle? Before Bruen, courts could answer that question with a shrug. After Bruen, history and tradition became mandatory, and history has no clear tradition of broad, lifetime disarmament for nonviolent crimes. That's why lower courts have split. Some circuits are now drawing distinctions between violent, nonviolent, and regulatory offenses. Others refuse. The Supreme Court did not prune these petitions. It kept nearly all of them alive. That alone signals that the felon question is not settled, not simple, and not disposable. More importantly, it intersects with a second issue, restoration of rights. Once someone has served their sentence, who decides when their constitutional rights return? Short takeaway bullets. 922 G1 is now a constitutional classification problem. Post-Bruen history shows no bright-line rule for nonviolent felonies. The court preserved the petitions instead of liquidating them. This is one of the rare areas where legal theory and real-world life collide. Millions of Americans have felony records that have nothing to do with violence, firearms, or public safety. Pretending they are outside the people forever is no longer intellectually defensible, and the court clearly knows it. Section 5. Immigration cases and the people definition. Alongside the felon petitions sat a smaller but strategically interesting cluster. Cases involving non-citizens and the meaning of the people. The question is deceptively simple. Does the Second Amendment protect persons or citizens? The Seventh Circuit recently ruled that undocumented immigrants fall outside the constitutional community and therefore lack Second Amendment protection. Other circuits have taken narrower readings, focusing on lawful presence or political participation. Still others have avoided the question entirely. Here's why the immigration cases matter more than their numbers suggest. Defining the people for immigration contexts indirectly defines the people for every context. Felons, travelers, reciprocity, and even sensitive places. A broad definition means self-defense is a human right rooted in natural liberty. A narrow definition makes it a licensed privilege tied to paperwork, geography, and political status. Short takeaway bullets. Immigration cases force the court to define constitutional membership. The people question is bigger than immigration. It sets boundaries for all 2A cases. The court refused to kill these petitions, which keeps the definition open. If the Second Amendment is to remain a right belonging to the people, clarity is no longer a luxury. It is the battleground. Section 6. Hammani Matters. If the court's silence today had a center of gravity, it was United States versus Hammani. Not because Hammani changes gun politics directly, but because it is positioned to supply the doctrinal language that lower courts need to stop improvising. The court releases a clear opinion on who can be disarmed and why it instantly organizes the chaos across 922 G1, restoration of rights cases, immigration cases, and even magazine and rifle bans. The court is likely holding fire because Hammani has not finished speaking yet. Instead of denying petitions prematurely, the court is keeping the docket intact so that Hammani can clarify the rules of engagement, and when that happens, expect dozens of cases to be GVR'd, granted, vacated, and remanded back to lower courts with fresh instructions. Short takeaway bullets. Hammani is a keystone case that defines disarmament doctrine. The court paused instead of pruning to wait for its language. GVR waves are coming, not denials. For gun owners, the practical translation is simple. The court isn't trying to end Second Amendment litigation. It's preparing to standardize it. Section 7. Mag bans on hold. If Section 1 was about what didn't happen, magazine bans are the most important example. Multiple states are currently enforcing capacity limits that strain even the loosest historical standards, and several of those petitions are already briefed for the court's consideration. Yet, no action, no denials, no emergency interventions. Silence in appellate law is rarely passive. It often means sequencing. The court does not want to answer the magazine question before it answers the bigger threshold question: who may be disarmed and on what basis? If violent versus nonviolent disarmament becomes a recognized doctrine in Hammani, magazine bans become harder to justify as public safety disarmament when the devices in question are standard for lawful carriers nationwide. Half of American rifles and pistols ship with magazines that violate state limits. That disconnect matters. Short takeaway bullets. Magazine bans touch the hardware, not the individual. The court is sequencing issues instead of mixing them. When disarmament doctrine clarifies, magazine bans may be next. For now, states can keep enforcing their limits, but everyone, including the states, knows the reprieve is temporary. Section 8, rifle bans alive. If magazine bans hover, rifle bans orbit. Duncan versus Bonta may be the flagship, but it's not alone. Multiple petitions challenge bans on AR pattern rifles, feature tests, and cosmetic criteria that have no analog in founding-era gun regulation. Post-Bruen, the historical justification problem hasn't gone away. In fact, it has gotten worse. The court could have cleaned the house today. It didn't. It preserved the rifle docket intact. That tells us the justices are not avoiding the question. They are simply not accelerating it until the doctrinal scaffolding is in place. Rifle bans will not be decided on vibes or fear. They will be decided on text, history, and tradition, and the court knows the lower courts are still trying to figure out how to apply that framework. Honestly, short takeaway bullets. Rifle bans remain active petitions. Nothing was denied. The court is waiting for the history doctrine to mature, not disappear. This is one of the few issues where the court knows delay increases speculation, not clarity. Gun owners should understand the stakes. Rifle bans are not a fringe issue. They define what the Second Amendment protects as arms in the modern era. Section 9, the GVR wave is coming. Anyone who lived through the 2022 post-Bruen cleanup remembers the GVR wave. The court granted, vacated, and remanded multiple rifle and magazine cases back to the circuits with a simple instruction: apply the new standard. Lower courts pretended to comply, slow-walked compliance, or resisted outright. That pattern may repeat. Today's silence suggests that the court intends to use GVRS again, but only after Hammani clarifies the disarmament doctrine. If that happens, dozens of petitions could be reshuffled at once instead of evaluated piecemeal. That is efficient and strategic. Short takeaway bullets. Silence today sets up coordination tomorrow. GVRS are a management tool, not a compromise. The court may use a single opinion to reorder an entire docket. For Second Amendment law, a coordinated GVR wave reshapes the battlefield far more efficiently than scattered grants or denials. Section 10. Why nothing is actually something. Most people follow politics, not procedure. They look for victories, losses, bans, reversals, and headlines. But the Supreme Court's power is often procedural. Strategy can look like inactivity because ordinary observers don't see motion until the ruling drops. Today, nothing dropped, but the pieces moved. Petitions survived. Issues stayed alive. The court refused to kill anything prematurely. In a constitutional area where government actors frequently try to run out the clock, delay favors the right-bearing public. For once, the clock is not the weapon. Short takeaway bullets. Inaction is a signal, not confusion. The petitions remain viable, which is the actual headline. Gun policy will now be shaped in sequence, not chaos. Gun rights litigation is no longer improvisational. It's being organized. The road ahead is getting narrower. When the court keeps cases alive, it isn't avoiding the Second Amendment. It's preparing to define it. The next moves won't be chaotic. They will be timed, layered, and doctrinal. That should make both gun owners and state governments pay attention for the same reason. The days of legal guesswork are ending. If you care about the Second Amendment, this phase matters. Supreme Court history shows that the biggest shifts rarely come with fanfare. They come through sequencing, consolidation, and correction. That's where we are now. Make sure to stay informed, stay prepared, and follow these developments closely. And if you find value in this coverage, consider subscribing so you don't miss the next major update. The real decisions are still ahead, and they're getting harder to ignore.